So let's imagine that there's a hearing and somebody is a witness, right? And so assume they would be in a box somewhere on your screen as the witness, and there may or may not be the counsel for a direct examination or cross-examination who's speaking from their box to that other box. Are there things that made you nervous about or concerned about the witness really just being like they're sitting in a chair in front of you, or have people off screen who might be whispering things to them, or their cell phone might be saying things? You know what I mean? This kind of stuff that you could see immediately if it was in a physical room, but it's very good.
Yeah. And that's a concern for people. You know, how do you know that a witness is really telling the truth? And I'm sort of in the camp of you don't. There's no magic that says that an arbitrator can look through their eyes and see deeply into a person's soul and determine if they are lying. But what an arbitrator can do is rationalize and think about, how does this person's testimony really match up with the evidence that is in front of them? And I don't think that a witness's oral testimony should be discounted at all by virtue of the fact that they are testifying in a virtual setting. Similarly, if somebody were only presenting a written submission, the concern that they were getting ideas from here and there or being told what to write, that would already exist in the paper document. So, you know, I'm not sure how much of a bigger or worse problem it is in the oral setting, but it makes it all the more important to be on top of the documents that have been submitted. Okay.
And that's where you have your other screens with all the documents there that you can go to. And if they're well organized by the clients or by the parties, then you can go boom to 34, where that's the one he's talking about or she's talking about and all that. Got it. And how about, let's talk about cross-examination, right? The wonderful cross-examination moment. How, in your experience, is that different, say, online than offline? In terms of, I don't know, all those theatrics that you were describing a little bit earlier, you know, how do they play? How does a great theatrical courtroom player look to the arbitrator now that they're online?
Once upon a time, there was a presidential debate in the United States. How did it look to audiences across the world when the two debating were interrupting each other? At the end, everyone was annoyed. And annoyed is, I think, the last thing that anyone wants their arbitrator to be. So we set out at the beginning that it is important for whoever's speaking to actually be given the opportunity to finish their sentence or finish their thought. And that importantly, it's not cross-examination. For me, it's not a contest of who gets to say the most, the longest. What we're there for is the information. And I also promised that if I felt it was getting repetitive, or if I had additional questions that I needed to raise, that I would raise those. Okay. But of course, giving the parties the first opportunity to address the witness and the witness's evidence.
Okay, I see. And then another issue that I could see happening in the hearing is everybody's happy to show up and do the hearing and their witnesses and all that, and it's that sort of collegial international arbitration experience. But what do you do if you have a party who does not show up? You know, especially in the time of this pandemic and all that, you know, all of a sudden a party disappears. And then you want to move the arbitration forward at a reasonable pace, and probably some pressure from the arbitral institution for you not to just take the pandemic off, so to speak. So what about it? How do you deal with those kind of situations?
Actually, the first thing that the parties that were participating, and I did, was we agreed in PO1 to waive certain time limits, because it turned out, this was the height of the pandemic, that the strict adherence to different time limits was not necessarily going to facilitate the case or guarantee the parties' due process, because we really had no way of knowing, is this a party that is deliberately not participating, or is this a party who is caring for someone, or is him or herself sick? So first was making sure that the party was actually informed of the proceedings, and the institution took the lead on that through email, on paper, with different mailing services. And the institution was convinced that the party had received a notification. But in addition, I made it clear to the parties that, this is an arbitration of all three of them, one claimant, two respondents, and that things would be easier if the third would participate. And since they, coming out of a business relationship, had a better connection to him than anybody else in the room, it could be helpful for them to write to him and make sure that they did their best to bring him into the process. Now, he unfortunately never joined, but fortunately, the arbitration rules did not require his consent, his affirmative consent, in order for there to be an online hearing. I accepted the views of the participating parties and found that it was far more reasonable and feasible to have an online hearing, and that's how we did that. But then, in an in-person hearing, when somebody doesn't show up, it's very easy. Everybody just stays in the hearing room. You pull out your favorite book, kick up your feet, and wait out the rental period. Give that person, right, give them exactly the opportunity to participate at the hearing if they want to. And for this procedure, we had reserved several hours for the hearing, and we were actually done with the case presentation of the the parties participating after about 3.5 hours. So we left the meeting open for 3.5 hours. I read a book. The other parties assured me that they were available within a shout. And also during that, when I had to take small breaks, I would let the parties know that we were having a 5 or 15-minute coffee break, put a sticky note up on my camera, and leave the room. And it worked. Unfortunately, he did not participate, but I was able to do exactly what an arbitrator would do in the in-person setting to ensure that somebody had every possible opportunity to participate.
Yeah. So I hear notice, an opportunity to be heard, really being looked at, and the flexibility that the arbitral rules provided allowed you to look at that. Now, beyond the arbitral rules, I don't know what the place of arbitration was for this particular case, but the law at the place of arbitration, whether it is, how we could call it, online arbitration friendly or not,
Not very. It required, of course, the law of the seat was silent on online proceedings, so they were not banned, but they required the arbitrator to sign an oath before a notary, promising to listen to all of the testimony and to give it all fair consideration prior to the start of any testimony. And that put me in a difficult position at the height of the pandemic to think about when will I ever be able to find a notary to swear this to. And
Right.
fortunately found one in time, but it was very stressful. I've never signed a document under such stress, let's
Yeah,
say.
interesting. And then do you have to exhibit the document to the parties at the time of the hearing or something? Is that part of what's required, or just that's done formally, that you have that in your papers, that you've got this notarized doc, or is that given to the institution? Maybe that the arbitral institution.
If the institution had ever needed it, I would forward it on, but it was for my records
Okay.
to comply with those requirements.
All right. This is going to sound very mundane, and I apologize for it, but
there's no such thing as mundane.
Okay. Arbitrators are compensated and they have expenses. Arbitral institutions have administrative costs that are there. Did you have to address that? Were people making their payments to, I don't know, the institution as opposed to you, or how did that whole side? I'm imagining an ad hoc arbitration situation where there isn't an institution. And, when you're virtual like that, how does this all kind of work? It's probably just as simple as buying something on Amazon, but I figured I'd ask you how it works.
Well, for this institution, everything related to that went through the institution. So I didn't have to touch it at all. But I've also done ad hoc cases. And what has been helpful for lots of tribunals is to hire, or rather to outsource it to an arbitral institution to act as the funds holder and to do all of that management.
Okay. Oh, excellent. So you've now heard from the parties, you've heard these incredible witnesses, and now I'm going to kind of segue to another subject now, which is that you're now deliberating and writing your award. Okay. How did the online space change any of that with regards to how you went about, as opposed to those offline binder kind of situations that you dealt with before?
I'm not sure. I mean, it was different in the sense that I was a sole arbitrator and that it was my award. But I informed the parties that I might request a post-hearing brief, like just short question and answer from them. But as I was going through everything, I really had everything that I needed. All of the gaps had been filled in the hearing. And there's a practice, I think it comes out of the ICC, where, or I think it's the ICC who did this study, that arbitrators who go to the hearing with a working paper already prepared, and then who stay after maybe a day, up to a day, to deliberate with their colleagues, they prepare awards faster than everybody else. So I went into this hearing with a working paper that set out all of the mundane points and had the summaries of their arguments and space for the questions that I had, or the gaps that I saw were there.
Okay. And then after you finish this award, and we always imagine this award, or maybe I'm just too old school, but we imagine the award as this 40-page, 30-page document. It's got a signature. It's got a signature made at some place in the world, place of arbitration. How did that award, and was it an electronic signature or a PDF? How did the award get communicated to the parties or notified to the parties? In what format was it done? Those kind of things.
I believe it was notified to the parties as a PDF document through the institution, but I did send the institution several signed copies. They were not notarized copies, thank goodness.
Uh-huh. Uh-huh. But the
Yeah.
institution has the original signed one, several ones that's there. That we come back to the, I don't know, the physical or offline world at the end with that magic hand signature there with the date and made at and all that stuff. Well, it's that's really, really interesting, I think. And I wondered, maybe sort of as a last note here, for people who are going into this area and maybe going from domestic arbitration to international and are seeing their life all of a sudden thrown up in the air from being sort of their greatness offline, now going into online. Do you have any sort of, I don't know, words of wisdom or words that you would try to say to those people as they make this transition?
It's not a very big transition. Most deliberations have been done online for years. Tribunals emailing one another, sending drafts back and forth. That hasn't changed. And most tribunals, well, most lawyers are still very far away from their arbitrators, and most things are still happening over email. You know, as for online hearings, I think I've gotten okay at looking straight at the camera.
Yeah, I haven't. I'm looking at you, and I see what you're saying. Yeah.
It's hard to do, but to remember that the point of a hearing is not to see who can have the most poise and look the most confident. The point of the hearing is to make the transcript that will help in the preparation of the award. And we still get those hearings, we still get those those important transcripts out of online hearings.
Yeah. Okay. All right. Well, thank you, Katherine, for spending some time with us today and walking us through these aspects of this kind of new world that is kind of like the old world, but it's the new thing. And really sharing your experience with us. Greatly appreciated, and we want to wish you all the best.
Can I ask
Thank
a
you.
question, Ben?
Oh, yes. Now we can go to questions. Yes.
First, thank you so much, Katherine. That was extremely interesting. I love the comments and the tips and the recommendations you gave. And I'm happy to hear that the transition was very easy, because this is exactly what we also think. And thank you also for the tip about standing up. This is a very interesting tip. I think no one thought about it. That I will note that down. I was curious to note about the case in which you had to provide a notary, an official document from a notary. Was that request in the case with the applicable law, or is it simply because the hearing was going virtual that one party felt more comfortable to ask you for such a document?
Oh, it was contained in the State Arbitration Act.
Okay, so that
as
is
a requirement.
Right, so it wasn't a requirement particularly related to the online hearing.
Right. It was a requirement related to any kind of hearing. What made it awkward was that the entire state was on lockdown, and I had to, I had to find a notary and try a socially distanced signature. But I needed that in order to protect the award that would come out of the proceedings.
Definitely. And were the parties afterwards, did they feel comfortable, and did they take the procedure forward without raising any objection or any issue?
Yes, they were comfortable, and we completed the entire case.
Very interesting. This is the first time I hear that. Well, thank you so
Oh,
much.
good.